Good evening, everybody. It's nice to see you all here in the Lakeview room. And good evening to those online. I believe we're opening the webinar now. And so I'm slightly filibustering while I wait for confirmation that that's happening. And before I start. So when I see the signal, then I will get underway. Okay, so thank you all for attending and welcome to this guest lecture from two illustrious speakers. The topic is human rights in migrant and asylum cases. And I'm Matthew Gillett, senior lecturer here at the University of Essex, and will be moderating the discussion, which will be led by two persons of extensive experience and not just academic, theoretical experience, which is important, but in some ways, even more importantly, very clear practitioner experience applying these human rights in a variety of circumstances in multiple jurisdictions. The topic for today focuses on humans in vulnerable situations, persons on the move, and we do have an emphasis on women and children. This is partly because it's International Women's Day this week, and partly because special considerations do need to be paid to these groups when they are in situations of migration, asylum, and potential human rights issues arising. The talk today is supported, we're led by a grant from the Impact Fund that Dr. Sabina Garahan and myself have received. So we thank also Sabina for helping organize, and we thank Amy and Kat from the events team for their fantastic support. Most importantly, we thank the speakers that are here, and in order, I will first present Judge Patrice Wellesley-Cole, who is the current president of Graduate Women International, GWI, which is an ECOSOC consultative status recognized organization. She's an honorary fellow and graduate of St. Hugh's College in Oxford, and as a barrister has practiced in London and Freetown, Sierra Leone. Most importantly, for today's purposes, she was a tribunal judge who sat in central London for 17 years on immigration, asylum, and human rights jurisdiction cases. She has worked also in the international front with the UN Special Advisor on Genocide, Under Secretary General Alice Wairimu Ndiritu, and also volunteers on a weekly basis with various charities, including Médecins Sans Frontières and the British Red Cross in their refugee support. Our second speaker, we're very lucky to have here online, is Felipe Gonzalez Morales, and he is the former United Nations Special Rapporteur on the human rights of migrants. He was in that post from 2017 to 2023. He's a professor of international law at Diego Portales University in Santiago, Chile. And from 2008 to 2015, he was a commissioner and the rapporteur on migrants at the Inter-American Commission on Human Rights. And he was president there between 2010 and 2011. So we have a wealth of knowledge and experience, and the format for today is a relatively straightforward one. We will hear from Judge Patrice for approximately 20 minutes. We will then hear from Felipe for approximately 20 minutes, and then there will be space for questions from those present in person and online. And so I strongly encourage you to use this opportunity. I also extend a warm welcome to our speakers, and we'll pass over the floor now to Judge Patrice. We are in your hands. Thank you very much.
Thank you, Dr. Matthew Gillett, for the most warm welcome, and it's great to be here in Essex University today. I will be talking about my time as a judge and asylum and human rights cases that I heard. Human rights keep society fair, just, and equal. Arbitrary detention, crimes against humanity, forced disappearances, sexual and gender-based violence, VAW, genocide, summary execution, and torture are all human rights violations. Genocide has been called the crime of crimes. This year is the 75th anniversary of the Genocide Convention. In addition, inhuman or degrading treatment or punishment by or on behalf of the government or non-state actors are further examples of the most egregious, as is Uganda's anti-gay bill, the Holocaust, and modern sex trafficking. The right to life, liberty, freedom from slavery, freedom of opinion and expression, the right to work, the right to education, human rights that all of us take for granted. Set out in the UDHR, Universal Declaration of Human Rights, including the right to asylum, all 30 therein are equally important. To be restricted, such rights must be lawful, necessary, proportionate, and legitimate. This happened notably during the pandemic in England. The House of Commons Select Committee examined the impact of COVID-19 and measures taken to address the public health emergency, children's right and access to education and other essential rights. Submissions focused on Human Rights Watch concerns in relation to school meals, food insecurity, digital exclusion of some teachers and students, and the effect of the pandemic on children with disabilities. Absolute rights are freedom from torture, freedom of thought, and freedom from slavery. The American academic Virginia Gildersleeve, Dean of Barnard College, and one of the co-founders of our organization, TWI, was known as the International Federation of University Women up to 2015, was the only woman delegated by the US government to the April 1945 San Francisco Conference, which negotiated the UN Charter. It was she who persuaded delegates to adopt for the UN the following aim: universal respect for human rights and fundamental freedoms for all, without distinction as to race, sex, language, or religion. She also inserted in the Charter higher standards of living, full employment, conditions of employment, economic and social progress and development, insisting the Charter established the Commission for Human Rights, which under the direction of Eleanor Roosevelt, drafted the Universal Declaration of Human Rights 3 years later as a result of World War II. We are proud that our co-founder was so instrumental in its creation, the contents of which have been elaborated and incorporated into subsequent international treaties, regional human rights instruments, and national constitutions and codes, including the 1998 Human Rights Act here, Bring Rights Home, which came into force on the 2nd of October 2000, allowing UK nationals to rely on the ECHR, European Convention on Human Rights. Ironically, over a year later, the US was still in the grip of segregation, when the Black singer Harry Belafonte, back in 1959, wanted some African students to study in America. After arrival, one of these students married an American lady, and they had a son. The marriage broke down, and the wife had to bring up the son on her own with her parents and with her second husband. In 2008, that son became the 44th President, Barack Obama. In 2011, President Obama awarded Harry Belafonte the Presidential Medal of Freedom, given to those who have made a significant contribution to civil rights, and who have laid the foundation for present and future leaders in the battle for human rights. Today in England, we have the Illegal Migration Act and the Rwanda Bill. The victims of the Windrush Compensation Scheme is a legal challenge to the refusal to give legal aid to victims to be heard. The Home Office has announced that Ukrainians here under existing schemes will be permitted to extend their visas. I sat in the first-year immigration tribunal in London. Now all our hearings are recorded, files are digitized and uploaded digitally. Judges work from 2 or 3 screens, so courts can be virtual, hybrid, or live. When a judge presses a computer button, the judgment goes to the judicial portal. Currently, many cases are EU settlement and sole responsibility. That is where a parent sponsors their child and they have to prove that they are taking decisions about their upbringing. And most of them, those children, come from 3 countries: Nigeria, Ghana, and Zimbabwe. Our system is adversarial, but may become inquisitorial. If, for example, an appellant is unrepresented, see the Supreme Court case of Lord Carnmouth in MN and KY in 2014. The standard of proof is a lower standard, that is reasonable likelihood. Now, women and children can be vulnerable and are vulnerable. And the Refugee Convention directly engages them. And under the Refugee Convention, we have PSG, that is particular social group. The leading case on women for that is Shah and Islam, decided back in 1999. And that case involved conjoined appeals from 2 Pakistani women who were victims of physical abuse by their husbands. Children, of course, could also be part of PSG, for example, former child soldiers. So human rights overlap with the Refugee Convention. Article 2 is a right to life. Article 3 is inhuman and degrading treatment. And Article 3 can even be invoked for health cases, such as AM Zimbabwe in 2020, where a deportee who had HIV was allowed to remain because of his health. Article 8 is the right to family and or private life. And it is a qualified, not an absolute right. In the leading case of Bioko Betts in 2008, held that other family members should be included in the balancing exercise for Article 8. And there is a procedural aspect to human rights as well. As I've said, women and children may be vulnerable witnesses, and so hearing their appeals will require considerable care. The children, we have what we call the Section 55 duty under the Borders, Citizenship and Immigration Act 2009. This requires judges and decision makers to take into account the best interests of the child in all appeals, including asylum and human rights cases. And the authority for that is the 2011 one, ZH Tanzania. So we have a great deal of guidance on children in court. As was said, by Sir Ernest in AM Afghanistan 2017, a child is foremost a child, or he or she is a refugee. The tribunal should be familiar with the contents of the Equal Treatment Bench Book. Chapter 2 contains guidance on children and young people. You're all aware of the UN Convention on the Rights of the Child. It sets out a number of key principles, including Article 3, best interests of the child must be a primary consideration in all decisions and actions that affect children. Article 12, every child has a right to express their views, feelings, and wishes in all matters affecting them, to have their views considered and taken seriously. This right applies to proceedings in the tribunal. The tribunal has a safeguarding role to promote the welfare of children, which furthers the overriding objectives of the procedure rules and does not interfere with judicial independence. We also have practice directions. The tribunal must follow practice directions for vulnerable adults and sensitive witnesses issued on the 30th of October 2008, and also 2010, Joint Presidential Guidance Note, such vulnerable adults and sensitive appellants. That's another guidance note. Failure to do so is likely to be a material error of law. The vulnerable witness practice statement reads, child, vulnerable adult, or sensitive witness will only be required to attend as a witness and give evidence at a hearing. The tribunal determines that the evidence is necessary to enable the fair hearing of the case, and their welfare will not be prejudiced by doing so. And we have the Joint Presidential Guidance, which confirms that an age-disputed appellant should be treated as a child. Even though we do have quite a few cases where the Secretary of State will dispute if the child is a minor, but we err on the side of caution, we treat them as minors. We also have the joint presidential guidance, referring to the duty of the tribunal to determine the extent of any vulnerability, the effect on the quality of the evidence, and the weight to be attached to it. And we look at the evidence as a whole in the round. This shall be addressed at an earlier hearing and at the latest at the beginning of the substantive hearing. Now, in cases when you have a child, an appellant's representative is primarily responsible for identifying any issues of vulnerability and any appropriate adjustment. When the representative is unprepared or the appellant is unrepresented, then the tribunal should consider what measures to take, including steps to make the hearing room more child-friendly, using case management powers. It is advisable, but not mandatory, for a child to have a responsible adult present at the hearing. The legal representative cannot be a responsible adult, so it's normally a parent. So what happens on a typical hearing day? Well, court begins at 10. Banging on the door, court rise is what my clerk will say, ushering me in. I say, good morning, please sit down. Bowing my head, everyone in court is seated. I go through the cause list, that's the number of cases in my list, or judicial housekeeping. I ascertain that the lawyers are ready to proceed. Now, on one side, you have the lawyers representing the appellant, asylum seeker, or immigrant. On the other side, you have what are called Home Office presenting officers, HOPOs. They represent the Secretary of State, in-country and out-of-country appeals. In the middle, you have the appellant and usually an interpreter next to him or her. I sit on a dais with the Royal Court coat of arms behind me, with the words, Dieu et mon droit, God and my right. This demonstrates that justice comes from the monarch, and the law court is part of the royal court. Judges and magistrates are therefore officially representatives of the crown. The presence of the royal arms explains why lawyers and court officials bow to the judge when they enter the courtroom. They're not just bowing to the judge, they are bowing to the coat of arms to show respect for the monarch's justice. As judges, we take the judicial oath, oath of allegiance to the crown. So I was then a full-time judge in central London, had my own chambers. My late father was a doctor in Newcastle in north of England. He used to talk to a fellow doctor. And he said, oh, how's your son getting on? Oh, he's doing very well. He's going to read law at Cambridge. That son became the Chief Justice, Lord Peter Taylor, who our hearing centre, Taylor House, was named after. They taught Lord Taylor of Gosforth. As a full-time, I now had tenure, security, and a judicial itinerary, working weekdays. Now, as the years progressed, patterns emerged of where asylum seekers came from. It started off with Kosovo, with the war. And we had a lot of Colombians fearing FARC. Then Tamils from Sri Lanka, fleeing the civil war. Zimbabweans opposed to Mugabe. Then Kurds from Turkey. The work became more complex, with changes in the immigration rules, legislation such as the Human Rights Act already mentioned, and the growing regime of asylum and deportation authorities. We were not mere immigration adjudicators, we were now judges in the Immigration and Asylum Tribunal, regarded with the employment judges as the twin pillars of the tribunal jurisdiction. Ours was the only jurisdiction where your determination may lead to someone being returned to torture or death. There is an appeal from our judgments, known as determinations, but it's not automatic. For example, in a deportation appeal, an immigrant who's an appellant will have a criminal record, maybe in a gang, so there's evidence from the police, have children, and have lived here for most of his life, so they could rely on asylum and Article 8, the right to private and or family life. We heard cases on statelessness and nationality. We also conducted pre-hearing reviews and did bails. With bails, we delivered extemporaneous rulings. That means straight away. And there is a presumption in favor of immigration bail, but this can be rebutted. Now, with immigration bail, you still have to take sureties, that is, people who put up money to make sure they don't do a runner, abscond. One of my colleague judges asked a very nervous lady surety, are you the wife or the girlfriend? Not the question to ask. You have to be very careful how you ask your questions. You had to give a reasoned decision in bail, and then all our determinations, because with bail, of course, it's about the liberty of the subject. As a full-time judge sitting at Taylor House, we had all the tools at our disposal. Computers, tech support, an extensive library with the research staff, colleagues to bounce ideas off, headed by a resident judge. We were in teams led by a designated immigration judge. Part-time judges had access to such tools, not their own chambers or court computers. As a full-timer, my sitting pattern was sitting as a judge one day, writing up the next. Court procedure for asylum appeals was similar to immigration ones already described. Evidence for asylum differed because those seeking asylum feared persecution for a convention reason, such as political opinion, religion, race, or particular social group. As I've said, the standard of proof is a lower one, reasonable likelihood. I've heard asylum appeals from Castro's Cuba, a musician who defected, and also from Kim Jong-un's North Korea. Apart from their oral testimony, we rely on objective material, such as country reports, to assist us in drafting our judgment-style determinations. With my judicial colleagues, we kept up to date with not only cases and legislation, but the political situation in countries where appellants come from, who appeared before us. And of course, some years ago, I had two separate unconnected cases in my court, both men claiming refugee status were from Bhutan. They both asserted they feared persecution on return because they had taken part in an illegal protest and would be marked men. I listened intently to their evidence. They were cross-examined by the HOPO. Now, with asylum, we reserve our determination. We don't give our judgment straight away. We give them what we call anxious scrutiny, to think about it. Which is what I did. And it emerged that no such protest had ever taken place. Such mendacity. Their credibility was very much an issue. Which is why, when we as judges hear such asylum appeals, the first question we ask ourselves is, do we believe them? The Chief Justice is responsible for arrangements for training the court's judiciary, which we all had to undertake through the Judicial College. Established in 1979, formerly the JSB Judicial Studies Board, the Judicial College has three elements of judicial training: substantive law, evidence and procedure, and where appropriate, expertise in other subjects, the acquisition and improvement of judicial skills, including where appropriate, leadership and management skills, and social context within which judging occurs. I was regularly trained with my colleagues, even on social media. In one session, judges were asked who the most popular singer was on social media platforms. My colleague judges muttered, Madonna, Beyonce, then Lady Gaga. And one old boy muttered innocently, and who is Lord Gaga? Our judgments and determinations, as they're called, are repeatable if there's an arguable error of law. For example, if the tribunal doesn't follow legislation or case law. I always strove to make mine Court of Appeal proof. Many of our appeals did go to the Court of Appeal. Mine, 2009 MA Pakistan was one that did, fortunately I was upheld. Some go to the Supreme Court. Appeals only go to the Supreme Court on a point of law of public importance. So, life as a judge in a high-profile specialist body, the first-tier tribunal was demanding but stimulating, privileged to serve. Socrates said that a judge's role was to listen courteously, to answer wisely, to consider soberly, to decide impartially. The 2002 Bangalore Principles of Judicial Conduct are judicial independence, impartiality, integrity, propriety, and appearance of it, equality of treatment of all before the court, competence and diligence. Another quality required of judges from the framework of judicial abilities and qualities published by the JSB is compassion under the umbrella of community and authority, along with fairness without arrogance and sensitivity. The law is a law and must be applied evenly and consistently, cannot be modified on the grounds of sympathy or emotion. Judgecraft is not mechanical or abstract. It is an intensely human process, the Canadian judge Sharp said in Ontario. Compassion is part and parcel of the law. This accords with my own experience as a judge. All of us have been tested by particular cases, from asylum to students, marriage cases, dependent relatives. In 2012, Reverend Brian Shipsides was jailed for 4.5 years for conducting over 250 sham marriages for 2.5 years at his East London church, earning £30,000. Described as a massive and systematic immigration fraud, he was convicted of conspiracy to facilitate unlawful immigration. His fixer got 3 years. At Taylor House, we had some of these appeals. I allowed mine because I was satisfied it was a genuine marriage. For our appeal, if we have one, if it's borderline with asylum, because of the lower standard of proof, arguably it should be allowed. As criminal lawyers opine, it is better that one guilty man goes free rather than one innocent man is convicted. That is why, as practicing barristers, you have to choose between two briefs, civil and criminal. Take the criminal one, because it's about the liberty of the subject. But in all our determinations, we had to make clear findings and concentrate on the issues. We did have some challenging cases, including a Jamaican gay who feared return due to his sexual orientation. He brought banner-waving protesters to court. I noticed them demonstrating outside the tribunal building beforehand, thinking it wouldn't be my case as I entered the building, but it was. In the hearing room, I firmly explained court procedure to them, stressing their behavior was not helping their friend's case. Happily retired or unretired, having taken early retirement in 2017, I'm now immersed in voluntary work as GWI president and Rotary president. Who said, if you want peace, you must work for justice? But I'm still regarded as a judge. At a South London informal lunch party, I was introduced as a judge. I quickly said this was no longer the case, I was retired. At that point, a charming lady, her eyes twinkling, looked at me and said, smiling, once a judge, always a judge. Once a diplomat, always a diplomat. Thank you.
Thank you very much, Judge Patrice. And it certainly impressed on me the difference between theory and principle and the application on the ground in specific cases where it's not as clean and it's not as easy. Sometimes you have to put aside empathy for someone that you might feel is in a very difficult circumstance, but has to be assessed according to the same law as everybody else. And I certainly felt that coming through from the variety of cases that you mentioned in your practice. So thank you very much for sharing that experience. And we will now set our sights more internationally with Felipe. And you have a 20 minutes or so, more or less, it's over to you. And we're very much in your hands. Thank you for joining us online. We wish you could be here in person, and hopefully we will get you here in person in the future. So thank you very much.
Thank you very much, Matthew, and thank you very much to the Human Rights Center at the University of Essex for the invitation to participate at this webinar for this hybrid event. Actually, I have never been at the University of Essex, and I can see some nice views in the outside there. However, I have a relationship with Essex, and I would like to stress the important role that late Professor Nigel Rodley, who was one of the founders of the Human Rights Center in Essex, played regarding my country, Chile, when he was the Special Rapporteur on Torture. And I remember that he did a visit at the beginning of the transition to democracy, and that was very important in order to reverse the trends and practices of widespread torture that took place during the dictatorship of Pinochet in Chile. So I have that link with Essex, and on other occasions I have been also in some international meetings with professors from there. I would like to start by saying that the issue of cases on migrants and asylum, migration and asylum, reflects the overall debate at the international and I would say at the domestic level of many countries as well, which is a debate around human rights of migrants and refugees vis-a-vis security. And as you may have seen in discussions in the UK, and also this is a common feature in many countries around the world, the current trend really is toward more security, enhanced security, and invoking security all the time as a way to restrict the rights of migrants, asylum seekers, and refugees. Of course, security is a legitimate concern, and there are a number of human rights, not all of them, which can be legitimately limited on the basis of security. but human rights of migrants or of any person should be the general rule, and any limitation to them, including security, should be narrow and focused on the specific situation, and should not be addressed at the stake of human rights. Having said that, I would divide my presentation into three parts. The first one regarding the role of judges, the second one about the use of international law by domestic judges, and finally, to the extent that time allows, I would refer to a number of the main substantive issues that judges may have to address in cases. First, regarding the role of judges, some of the questions that I present here are: what powers are migration judges expected to have? They don't have the same powers in all countries. Second, how proactive should they be? Third, should they belong or not to the judicial system as such? Fourth, how does the issue of due process of law and the rule of law also are relevant in this regard? And finally, the issue of access to justice for migrants and asylum seekers. I'm presenting these questions because I would say that there are many different ways of regulating the role of judges in regard of human mobility cases. I will speak about human mobility as a generic topic, it's a generic word, including migrants, refugees, asylum seekers. So there are many regulations. In some countries, judges have much more powers than in others. In some countries, the legislation forbids that judges go into some sort of decisions. So that's completely different from one country to another. And what I have seen over time, especially in my region, Latin America, but this is also applicable to our countries, it is that judges are becoming more and more involved on human mobility issues. This may not be necessarily the case of Europe, because the issue of migrations has been around in Europe for decades, but in our regions of the world, it is a trend, I would say. Now, this doesn't mean that these judges who deal with human mobility cases have strong powers. They do sometimes, they don't on other occasions. Sometimes, as in the United States, for instance, there are certain decisions that a judge simply cannot do. For instance, if a person has committed a crime or a misdemeanor, which has a penalty of 1 year or more, and the administrative authorities have decided that he or she has to be expelled from the country, a judge cannot invoke humanitarian reasons to avoid the expulsion of that person. So there is no way to overcome the administrative decision by a judge in those cases. And I would say that this is a situation that occurs in our countries as well. Not sure about the United Kingdom in this regard. I also ask about how proactive are the judges, because in continental law countries, unlike the common law system countries, judges are not expected to play such an active role usually. I would say that this has been changing over the last few decades, both in continental Europe, in Latin America, and in our regions as well, to some extent. But still, it's not the same proactivity that judges usually have in a common law system. So it is expected that statutes will take care of most situations, and that the role of the judges will be simply to apply those statutes, which I would think is a fallacy, really, but that is the predominant way of seeing it. I also mentioned the issue of whether the judges belong or not to the judicial system. And I make this point because in a number of countries, including the United States, the migratory judges do not belong to the judicial system. In the United States, the migratory judges belong to the Attorney General's office. And there are different sort of regulations in this regard. And in some countries, people sometimes are not familiar with the issue. I mean, not lawyers, but lay persons are not familiar with the issue that the migratory judge is not a judge in the same terms of those judges who belong to the judicial system. This takes me to the issue of due process of law and more generally about the rule of law. And I mentioned this because I think that, this was my experience during my tenure as a special rapporteur, which ended 4 months ago, that in a number of countries which are very strict in applying due process of law for their own citizens, the same not necessarily occur when referring to migrants, especially migrants with an irregular status. So this leads to discrimination in the way a state treats the foreign residents in the country. And this may have very different aspects that we can discuss later, but in many respects, the procedures are applicable to persons in migration cases and refugee cases would not be really applicable, would not be acceptable, I would say, for nationals in that country. And then there is the issue of access to justice. This is an issue that I specifically addressed in a report to the United Nations General Assembly. And I think this is a key aspect, because even if you have the possibility of bringing your case before a judge, which not always occurs, many times cases are decided by the administrative level only, but even if you have that possibility of bringing your case to a judge, if you don't have legal representation, this may be really problematic. And I have seen statistics, for instance, from the United States, which reveal that a person, an asylum seeker, who has a lawyer, has 3 to 4 times more probabilities of getting refugee status granted than a person who does not have a lawyer. And of course, access to justice does not involve only legal representation, but other aspects, including the right to get information, adequate information, to get consular assistance, to be able to get a translator if necessary, and so forth. So that, I would say, would be the first aspect, the issue of the role of judges and the scope of the work of the judges in regard to human mobility cases. The second aspect I would like to address is the issue of the use of international law by domestic judges. In this regard, I would like to make a difference between international refugee law and the broader international law migration. And I do this because in the case of a refugee, there is a treaty, which is the Convention on Refugees and its protocol, which has a very extended ratification around the world and virtually by all countries in the Western Hemisphere. Many countries beyond the Western Hemisphere as well. So there is a common basis to deal with refugee cases, and this can be applied by the domestic judges as well. I would say that on the issue of migration, meaning migration in a specific, in a narrow sense, not including refugees, the situation is more complex. There are more complexities on the issue of international law migration. And this is because, unlike the case of international refugee law, in the case of migration, there isn't a treaty with wide ratification. The main treaty on migration at the United Nations is the Convention for the Protection of Migrant Workers and Their Families. But less than 60 countries of the UN, that is less than 1/3 of the countries of the UN, have ratified the Convention on Migrant Workers. So there isn't a common basis. And of course, as the judge was explaining to you, there are issues that can be involved, and so you can also resort to other human rights treaties. This is true. The Convention Against Torture, the Convention Against Discrimination against Women, the Convention Against Racial Discrimination, the Convention on the Rights of the Child, and so forth. But it's not that simple. You can see it. You see that there are a number of treaties that you have to deal with. It's not a single treaty like in the case of refugee law. Of course, in a refugee case, treaties can be used as well, if applicable. But in the case of migration, this becomes much more complex. So to begin with, there is the issue of the complexities of international law on migration itself. Having said this, I would also add that in a number of countries, there are obstacles presented by the domestic regulations and jurisprudence to apply international law by the domestic judges. So there are different sort of limitations in this regard. And I remember, for instance, this was not a case of migration, but I remember the case of Pinochet in the United Kingdom in the late 1990s, early 2000s, when I learned that for a judge in the UK to apply the Convention Against Torture, which was invoked regarding Pinochet, it was necessary that a domestic law, had been enacted. So there wasn't the possibility of a direct application if no domestic law was enacted. This is not the case in many countries. I would say in most countries, once the parliament ratifies a treaty, that treaty can be immediately applied by a judge. But there might be other sorts of limitations. So I would say that in the use of international law and domestic judges, there is the issue of the complexities of international law migration, and then these obstacles presented by the domestic regulations themselves. Having said this, I would say that there is also an issue that depends on the proactivity of judges, really. And I have seen this in Latin America, where the Inter-American Court of Human Rights has played a very significant role, not only on human mobility, but also on human mobility. And this has provoked a more proactive role on the part of domestic judges in a number of countries of Latin America, which I think is very important. And the third aspect I would like to address in my presentation, very synthetically, are the main substantive issues at stake here. The sort of cases that judges have to deal regarding migration, which are the same topics that I myself had to address during my term as Special Rapporteur. And well, we don't have a case system at the rapporteurship, but we send communications to state, and we prepare country reports and thematic reports. And all these issues that I'm going to mention were addressed in different communications, urgent actions, country reports, and thematic reports to the General Assembly and the Human Rights Council. The first is the issue of the right to seek asylum. The right to seek asylum should be completely evident at this stage of international law and of the international community, but regrettably, it's not this. It's not this the case. As you may know, there are a number of countries, including the United Kingdom, which have established severe restrictions to the right to seek asylum. And according to the United Nations human rights bodies, this has been done in violation of the Convention of Refugees and on other conventions from the United Nations. And this is also the case of the United States. And regrettably, also it's becoming the case of a number of countries in Latin America as well. Then you have the non-refoulement principle, by which you cannot, a state cannot send a person to another country where he or she will be in peril of his or her life or integrity. Connected to this, is the issue of the prohibition of collective expulsions, by which a state cannot simply expel persons without considering them on a case-by-case basis. And you should also allow, state should also allow that person to go to the tribunals, which is the issue of access to justice as well, as you may see. A trend that is becoming, a practice that is becoming more and more common over the last few years is the practice of pushbacks, or devoluciones in caliente, as we call them in Spanish, pushbacks by which a state summarily expels a person. So it's a sort of collective expulsion, but in addition is practiced in a summary manner, in a summary fashion, sometimes in the borderland, sometimes in the sea. This has been an issue that has been repeatedly been addressed by the human rights organizations at the United Nations. Then there is the issue of the access to public services. To what extent migrants, especially those with an irregular status, are allowed to have access to public services is a matter of discussion in many countries. Connected to this, there is the issue of the need to establish firewalls. That is, that the public services do not share the information about the immigration status of a person with the migration agencies or the police, so as to avoid the effect of having the migrant feeling fear of going to a hospital or sending the children to a school or going to the before a judge, because they might be incarcerated and or expelled from the country. There is the issue also of migratory detention, that is migrants who are deprived of their liberty, not because they have committed a crime, but simply because of their irregular migratory status. According to international law, this should be an exception and not the rule. And in the case of children, migratory detention, according to international law, should not be applied at all. There is the issue of investigation of violations against migrants, including forced disappearances, extrajudicial executions, torture, and many other types of abuses of less gravity as well. There is the issue of non-discrimination and racism. I have seen that racism is connected to xenophobia on many occasions. I have worked together with the rapporteur on racism on many communications to states in this regard. There is the issue of gender and migration, which the Global Compact for Migration for the first time addresses specifically. The Global Compact on Migration was adopted in Marrakesh 5 years ago, and it explicitly states that there should be a gender approach to address the issue of the human rights of migrants. And to finalize, I will mention three more issues. First, the issue of labor rights, which I addressed in my last report to a General Assembly in October, including the right to form unions and participate to unions for migrants. There is the issue of civic participation and the recognition of freedom of association for migrants. And finally, there is the issue of the human rights of those who defend migrants, asylum seekers, and refugees. This is also a key aspect because without the human rights defenders, those persons in mobility are usually in a very difficult situation. This is what I would say. I am open, of course, for the debate, and I will stop here. Thank you very much.
Muchas gracias, Felipe. That's as much Spanish as I'm going to impose on everybody here. Really fascinating, and especially to hear about some of the common issues that are arising around the world, access to justice, child's rights, etc., but the differences in legal systems. In some systems, there being independent judges deciding these cases, and in some systems, this being effectively, if I understand right, members of the executive deciding, and questions that arise there. I do obviously have questions, and I am tempted to use my moderator's prerogative, but I will first see on the floor if we have questions, and this is opportunity to pose them to the speaker. Yes, Carla.
Thank you both for what were extremely interesting and rich presentations. I have a question for Judge Patrice.
Yes.
And the question relates to the context in which immigration judges operate, which has a tendency to be somewhat toxic and difficult in the sense that the government has quite a strong wish to keep the numbers down. And I'm wondering, in relation to the ordinary day-to-day judging, how that plays out, and how, like, what kind of tools the judges use to keep the focus on the judging, and to leave the politics to another room. And I don't know if that's a clear question, but I would just be interested in your view on that.
Very much for that. Well, as you know, we are independent of the government. We're impartial, and we do not make up our minds before we hear a case. And as I said, we have a cultural filter, and we have objective evidence, and we apply the law. We can't change the law. Now, some of my colleagues are not comfortable with deciding cases if people don't have a right of asylum. Because under the most recent act, they don't. If people come in a boat illegally, they're not allowed to claim asylum. You probably know that. Some of my colleagues are not happy with that. But otherwise, it is not a problem because we apply the law as it is. So with immigration cases, as you know, at the moment, the most controversial aspect of spouses coming in, you have to, at the moment, you have to earn 18,600. That's going to go up in April to 29,000. Now, we can't change that. We may not like it, but we can't change it. So my answer to you really is that we apply the law as it is, fairly and squarely. We're impartial. We don't make up our minds before we go into court. And as I say, I retired in 2017. We didn't have what you call such allegedly toxic legislation. It's become much more restrictive now. And as I say, we just have to apply the law fairly and squarely as it is. I know in America, judges are elected. I've been asked that, and of course, we're not elected in England. We have the separation of power, as you know, legislative. And the Supreme Court, as you know, has ruled against the government quite a few times, showing that we are independent.
Thank you. Yes.
I have a question about the difficulties and the differences between kind of the international law and the domestic application with regard to SOGIS cases. so LGBTQI people claiming asylum, in regards with the credibility issue, because of the nature of the cases. Often before fleeing the country, one of the main issues is not letting people know. There's been a number of high-profile cases from the UK, and so I was wondering if any of you two have any comments or thoughts about the difficulty in establishing the credibility, like in the credibility narrative, and how this is really kind of a discrepancy between the theory and the practice of the application.
Yes, if I may. Well, I think that, of course, this has to be decided on a case-by-case basis, but the situation of the country is an important one. And for instance, in the CARICOM countries, the former British colonies in the Caribbean, most of them still criminalize in penal legislation the consenting sexual relationship between adults of the same sex. This has been brought before the Inter-American Commission on Human Rights and court, which has repeatedly stated that that should be decriminalized, but most of the CARICOM states will maintain that policy. So in the case of a person escaping from those countries, it will be much more credible that that person is being harassed or threatened, and that his or her life could be in peril. But of course, this could be a case of persons in countries where that is not systematic, but it may well be that they have been affected.
Thank you. Well, I had quite a few cases of people who did claim on the basis of their sexual, and I usually allowed them because the bar is very low. And many countries, I think it's about 50 countries in the world, criminalize homosexuality. I forget the number, but it's quite a high number. Many African countries, many Caribbean countries. And we had a leading authority which said that even if there's an appearance that you might be gay, you should allow the appeal. So yes, because it's a reasonable likelihood in England, I think we have a very liberal interpretation of sexuality there.
I'm going to take my prerogative now with a question. It's also for both of you. And the situation where you have a child, or a minor, who is migrant or asylum seeker potentially, but the parent or parents don't have a valid claim, and so there's a basis, let's say there's a legitimate basis for them not to be allowed to stay, the parents. How do you balance the importance of family integrity, maintaining the family together, with the protection of the child, not, for instance, sending the child back to a situation where they may face risks?
Well, this is one of the most challenging areas, because we always say a child should be penalized for their parents' precarious immigration status. And we have a duty towards minor children, Section 55, which I mentioned. You have to look at the evidence in the round. They may invoke Article 8. The Secretary of State can do anything exceptionally. I should have mentioned that. In other words, if you make representation to the Secretary of State, he or she can allow that appeal. And what often happens in court, if they're represented, and they have lawyers and the presenting officers there, they might look at it again, and very often they concede. Sometimes they concede. So it just depends on the particular facts of the case. And you heard I dealt with some detail on the practice, direction, and guidance with children. It is a difficult area. Then you have, of course, disputed age as well. Very different. But yes, you need to look at it in the round, the evidence. I don't know what Felipe wants to say about that. But,
Yeah, when I was at the Inter-American Commission on Human Rights, we had a number of cases regarding the United States. Those cases could not go to the court because the US has not recognized the court's jurisdiction, but they stay at the Inter-American Commission, which is a quasi-judicial body like the committees at the UN. And in several cases, the issue was the consideration of the issue of humanitarian considerations, including situations at which an adult was about to be expelled, and he or she had children in the United States. And these were cases at which only, for instance, one of the parents was about to be expelled. And in those cases, often there was the issues of the lack of enough powers of judges that I mentioned before to address these humanitarian considerations in the United States. And also the issue that on many occasions these persons had been living in the United States for many years. And I think that in this regard, it's very important that humanitarian considerations are made by the domestic tribunals and authorities. And the European Tribunal of Human Rights also has an extensive jurisprudence in this regard. So it's not only the Inter-American system on human rights that established this issue. So more generally, I think that there are many situations at which it's very complex to apply the law at the local level by the domestic judges. I think this is an area that is particularly gray. To what extent international law can be applied by the domestic judges according to the domestic regulations, the issue of humanitarian considerations, especially when the expulsion of a person is at stake, the issue of lack of access to public services and the challenges brought before tribunals because of this, the issue of discrimination against migrants. So, and I have seen the evolution of the jurisprudence in many countries in this regard. So I think it's not a matter only of having regulations and status that judges will apply. I think that with the same status, I have seen very different decisions by judges in the same country over time. So I think it's very important for the civil society to bring those cases before the tribunals to challenge the legislation on the basis of constitutional law or international law and so forth.
If I could just add here, the two, I should have mentioned, if a child is here for 10 years, they can naturalize as British citizens, probably know that. So a lot depends on the age of a child, if their parents are not British. And of course, very often in our cases, we have one parent who is British and the main carer is not. So again, that's a rather different situation. So yes, if you've been in this country as a child for 10 years, you can naturalize or register as a British citizen. So good news for children, yes, it is. Yeah. That's why I concentrated on vulnerable children, the Section 55 duty. You've got to look at the best interest of the child.
Further questions? Yes, Martha.
Thank you both for the presentation. It was extremely interesting to listen to you both and your different experience. I just had a question regarding now we kind of see discussion around an emerging category of asylum seekers and refugees who are seeking asylum based on impacts of climate change. And I wonder how you see the role of judges changing and adapting to that, if at all.
Well, Felipe, do you want to go first, and then I can?
Okay. Yeah. Well, yeah. This is an issue I didn't mention, but in fact was a topic to which one of my reports to a General Assembly was specifically devoted. The one presented in 2022. And well, I know that there is this whole discussion about climate refugees and so forth. And the point is that not even UNHCR, the UN agency on refugees, speaks very much about climate refugees. And what the argument that I develop in my report, which, by the way, is the second report of the rapporteurship on this issue, because my predecessor also presented a report 10 years before. I think follow this line that because of the collective nature the collective impact that climate change surely have and will have. Probably the issue of trying to decide these cases on an individual basis is going to be futile. So it would be much appropriate to address this through other means, like granting other forms of international protection to these persons. And this can be done by governments without addressing each case on an individual basis. I think that the issue of extending other forms of international protection would be much more practical in this regard. In the case of Latin America, this is particularly true because the Cartagena Declaration, which is a regional instrument from 40 years ago, from 1984, includes an extended concept of refugee and other forms of international protection, including those escaping from different sort of great problems, and that would include the natural disasters and now climate change.
Thank you. I mean, I'm not aware of the British government having to deal with any climate refugee status applications. It may well come. And as I said, everything is on a case-by-case basis. Obviously, when making an asylum application, you apply to the Home Office first and they make a decision. It's only when that's refused they can appeal to a judge like myself. So it'll be interesting to see even when we get cases of this nature. As I said earlier, the Secretary of State can do anything exceptionally based on the merits of the case. An example of that is, you remember Zola Budd? You're probably too young to remember. Well, she was British overnight, so she could run for Britain. She was originally South Africa. The Secretary of State did that exceptionally. And the footballer, Al Bangura, he was made British very quickly. So the Secretary of State does have that discretion.
Questions? I have one for the two of you. And I should note that we have a small snacks, drinks, refreshment after this. And so I don't want to detain that. But do I see a question there? Yes, please go ahead.
Yes. First of all, many thanks for your learned presentations. They were both very rewarding. And I want to acknowledge your public service, without which our societies cannot flourish. So thank you for that too. My name is Paul Hunt. I'm a professor at the Human Rights Center at the Law School, and formerly Felipe, a UN Special Rapporteur on the right to the highest attainable standard of health. So if I may direct, I think perhaps two questions, Felipe, to you in relation to your position as Special Rapporteur between 2017 and 2023. One question I have is that during that period that you were serving as Special Rapporteur, there was an acceleration in the decentralization of the Office of the High Commissioner for Human Rights. There was an attempt to take resources away from Geneva and to have a better representation of the Office of the High Commissioner for Human Rights around the world. And that process hasn't finished yet. It's not an easy process. I'm interested to know whether or not, as rapporteur in those 6 years that you served, you felt that the greater number of offices of the High Commissioner for Human Rights around the world, whether that actually was a positive or a negative or a neutral matter for your country visits. And I'm not perhaps just asking you for your own experience, but the impression that you got. Was the dynamic changed on going on country visits when there were more officers of the Office of the High Commissioner for Human Rights around the world? That's one question. The second question, it's somewhat related to the climate justice question, but I wondered whether, I'm not saying you should have done, it's just a question, whether or not you looked at the international order, how it had been shaped, it continues to be shaped by colonization, and some would argue that the inequitable international order that we have today requires attention and reform. And I wondered whether you had any reflection on the impact of colonization and the growth of numbers of migrants and refugees. But again, both of you, thank you for your remarks and for your public service.
Well, thank you very much, Paul. It's good to see you. Thank you for your questions. Perhaps I should explain to the audience, in case they are not too familiar with the Office of the High Commissioner for Human Rights, that the mandates of special rapporteurs are very small. We have a support from one and a half, sometimes half a person or two persons. And usually we get more support from our own universities when we are academics. So that stuff comes from the Office of the High Commissioner for Human Rights in Geneva. But in addition to that, as Professor Han was explaining, there are offices from the High Commissioner for Human Rights around the world, not in all countries. In some countries, there might be one officer only. In other countries, there are big offices. I would say that during my tenure, I'm not talking about visits yet, but in general, I would say that it was very important to get the back and forth from the local offices at all times. So on a daily basis, or regularly, getting information from them or making consultations to them, that was very important. So sometimes what was more often, more common was that civil society organizations or organizations from migrants themselves would request the rapporteurship to move on a certain violation or issue. But sometimes the offices of the High Commissioners did so. And when the civil society did present these complaints, usually the first ones to which we tried to get the information from were the High Commissioner offices in the respective country. So I think it's important to have them. Now, having said that, in the case of the countries that I visited, I don't think in any of them there was a large office of the High Commissioner for Human Rights. And in some countries like Belarus or Nepal, there wasn't an office at all. They had been expelled at some point. So usually I had to rely on our organizations, our agencies from the UN for the logistics, such as ILO in the case of Nepal, or UNHCR in the case of Niger, or UNDP in the case of Belarus, and so forth. The fact is that the issue of migration is at the center of the international discussion nowadays. So many UN agencies from their own within their own mandates are also related to migration issues these days. So I did a lot of work with the UNICEF or with the UN Women, and in addition to UNHCR or OHCHR and ILO and other agencies. So it was not limited to the High Commissioner for Human Rights offices. On the issue of climate change, Well, I decided to prepare a follow-up report to the one presented by my predecessor in 2012 to address both the evolution of the treatment of the issue of climate change by the international organizations, particularly by the UN, and also the evolution of the impact of climate change on human mobility. And what I found out, and I don't think this is really something to be surprised of, was that there had been advances on the part of the UN and other international organizations, but to be sure, not enough advances as necessary, let alone in the case of most states. There have been also regulations adopted, but the climate change is going much faster. I would say that the reaction is that probably a reaction on the part of states. And on the issue of human mobility, sometimes this doesn't appear really clear. Judge Patrice was mentioning that she didn't get cases on this issue. And sometimes what occurs is that not even the person who is applying for refugee status is aware that his or her situation might have as one of the causes climate change. It might have been climate change that produced a famine in the country or made the situation much more grave, so the person had to escape from the country, for instance. So it's a difficult issue to address. And on the issue of the inequitable international order, well, let me mention one example. I concluded my mandate just after the situation in Gaza started. And in a way, I felt relief in one way, because it occurred to me on a number of occasions that lay persons would ask me, what is doing the UN regarding this issue? And that person would not be usually referring to special rapporteurs, but the Security Council or those mechanisms within the UN, which really has the strong power. And I would say also for the audience that don't know to what extent is familiar with the issue, with the special rapporteur system, the special procedure system, human rights. But the fact is that this is one of many branches, really. And in fact, this the name is Special Procedures of the Human Rights Council. And the Human Rights Council is comprised not by the rapporteurs, but by the states. So I think that with all our failures, or my own failures as a rapporteur, I think that the contribution from rapporteurs has been a significant one from the human rights committees, but the real power is still on the hands of states, and in equal ways. So, well, in the case of the Human Rights Council, the regional representation is more or less fair now. So most of those countries from Asia and Africa have the majority, but this is not the case of the Security Council, as you know, and the Human Rights Council doesn't have the same power than the Security Council. So I would say that there are many worlds inside the UN, and all this tension that I described at the beginning of my presentation between human rights and security is also within the UN, and not only between the human rights mechanisms and the states, but between UN mechanisms themselves. So it's a very difficult issue to solve, and the role for the human rights mechanism is try to bring human rights as at the center of the international agenda at the UN and at the international community.
Thank you, and thanks for the brilliant questions and extremely articulate answers. There was no rehearsal by any means of these, and so we really thank you. There was a question from online. Thank you, Carrie De Silva, although she had to depart. But I think we'll make it the final question, just in the interests of quenching any hunger or thirst. So, and the question I think was to Judge Patrice. It was about what changes you would like to see in the national system, I presume in the UK, particularly in relation to migration and asylum cases. Just a small question.
It's not just a small question. I don't think people could be penalised for claiming asylum coming here if they don't have safe routes. They could be penalised because Ukrainians are given safe routes. So I would like the government to ensure that people from more dangerous countries do have safe routes. I think I'd be happier with that. I think we also need to have more people dealing with the backlog of asylum cases, which of course has caused lots of problems. I know during COVID there were difficulties, but if we get through the backlog and give as many countries as possible safe routes, or not penalise those who come illegally, because it is under the human UDHR a right to claim asylum. That is a human right. And with HRA, the Human Rights Act 1998, which became law in 2008, women's rights are human rights. So if you're a woman asylum seeker, I think she was asking about gender equality, then that's how I'd like to see the law change.
Well, on that note, I will really amplify what Professor Hunt said as well, which was that it's extremely beneficial for us to hear from yourselves who've given so many years for public service in various capacities. And it's impressive that you're continuing to do this work and sharing this knowledge with what I would see as an upcoming generation of human rights defenders and advocates, many of whom, I don't know if you can see online, Felipe, today, but many of whom are here today. And I know that they've got very eager, inquisitive minds and will have soaked up everything that has been said. So I'll ask everyone to join with me to thank the speakers for what I think has been an excellent presentation.